Assumes, may we request Sheikh Ibrahim Ali to lead us in the invocation?
بسم الله الرحمن الرحيم الحمد لله رب العالمين الرحمن الرحيم مالك يوم الدين إياك نعبد وإياك نستعين اهدنا الصراط المستقيم صراط الذين أنعمت عليهم غير المغضوب عليهم ولا الضالين آمين اللهم وفقنا الله لما تحب وترضى اللهم لا تجعل الدنيا أكبر همنا ولا مبلغ علمنا اللهم أصلح لنا ديننا الذي هو عصمة أمرنا وأصلح لنا دنيانا التي فيها معاشنا وأصلح لنا آخرتنا التي لا يمادنا يا الله اللهم ربنا أتنا في الدنيا حسنة وفي الآخرة حسنة وقنا عذاب النار صلى الله على سيدنا محمد وعلى آله وصحبه وسلم برحمتك يا أرحم الراحمين والحمد لله رب العالمين.
Does the lady from Sulu wish to proceed with her interpolation of the Bangsamoro Labor and Employment Code? You may proceed. You may continue.
Thank you, Mr. Speaker. Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi ta'ala wabarakatuh. I believe we are now in section 50. I'm not exactly sure. Anyway, let me start with section 50 for today's session. Mr. Speaker, this section is about differently abled persons who may be employed, and this whole chapter 1, is about the our provisions regarding this kind of special workers as categorized under Title 5. And under section 50, Mr. Speaker, specifically paragraph B, it says that employment agreements for differently abled persons shall start, the wage rates shall start at 75% of the minimum wage. May we ask, Mr. Speaker, from the proponent, what is the legal basis for this this different standard, no? That is providing for wage rates lower than the minimum.
Yes, Mr. Speaker, the good MP Raisa is from the national law.
Well, Mr. Speaker, PD 442 was passed in 1974, but we have, after that, we've passed several, well, the national government through Congress passed other laws pertaining to PWDs. And specifically, I'm referring to RA 7277, which is the Magna Carta of for persons with disabilities. And this, under this law, under chapter 1, which is on employment of PWDs, section 5, it says a qualified disabled employee shall be subject to the same terms and conditions of employment and the same compensation, privileges, benefits, fringe benefits, incentives, or allowances as qualified able-bodied persons.
Yes, Mr. Speaker. Actually, the section B, you noticed the 75% on the for the start of the employment for the disabled. different able person. So from the starting.
I think, Mr. Speaker, that still allows the employer to give a compensation to the persons with disability lower than the minimum wage. Even if it's just a start, it still provides that leeway on the part of the employer to
I think
give.
there are also jurisprudence already on that matter that differently abled persons shall be entitled to the same minimum wages.
So I would like to ask the proponent, Mr. Speaker, to reconsider Section 50. I think under the Magna Carta for PWDs, there is such a thing as open employment, which allows PWDs who are equally qualified as able-bodied applicants to apply for jobs. But there's also what they call reasonable accommodation, which allows employers to improve existing facilities or to modify work schedules or to modify equipment or devices to accommodate differently abled employees. So that's those are the parameters, no? Those are the allowable acts on the part of the employer. Under the same law, there are incentives for employers to get persons with disabilities in their employ, like additional deduction from their gross income in the computation of taxes, and also if there's any modification of physical facilities, that would also be additional deduction from their net taxable income. So that even if the employer modifies, changes some of the rules or adds facilities, improves facilities or establish or install facilities, there are incentives that would offset whatever additional expenses the employer may incur. So I will just
Yes, I
raise the
agree.
matter during the period of amendments, Mr. Speaker. Okay, may I now go to Section 55, Mr. Speaker, and this is on elderly workers, also another category of special workers. And under Section 55, it says that elderly workers may be hired as special apprentices. So this is still under apprenticeship agreement, for apprenticeable positions. My question is whether after passing or after going through the apprenticeship period of 3 months or more, can the elderly worker be hired on a more permanent basis? No longer as an apprentice, but as a permanent employee.
Yes, Mr. Speaker.
And
The answer is yes. The answer is yes.
will there be an effect on if, for example, the elderly worker has already retired and is receiving pension, for example, from SSS, or has received it in bulk, will the employment after such retirement affect the retirement benefits that he or she is enjoying?
Maybe be clarified, what is the question? Is it during the apprenticeship or after the?
After.
Yes,
Because
Mr.
in the
Speaker.
apprenticeship, I believe that person is not really a permanent employee. But if the apprentice is eventually hired on a permanent basis, then he becomes part of the regular employment of the employer, correct?
Yes, in that case, Mr. Speaker, it would be the pertinent retirement law that will apply. So that in that case, they will be subject to the appropriate retirement law. Meaning if they continue their service, considering that they're retired, their retirement maybe the pension may be suspended and then will continue afterwards if they terminate their employment.
Yeah, may I butt in to clarify? The purpose of apprenticeship is in the context of training of or on the job training or training like the learnership. So after the apprenticeship, what will become of the apprentice? Will she become permanent
Depends on the employer.
or a regular employee?
It's the apprenticeship, Mr. Speaker, is looking forward to being hired by the employer. So if it's satisfactory to the employer, then he or she may apply for a permanent job, Mr. Speaker.
Yes, because in Hong Kong, they no longer use apprenticeship for senior citizens. They are either hired as contractual or regular employees.
Anyway, maybe we can review that further because the special apprenticeship, I believe, is while the same term, duration of time, which is more than 3 months of practical training. I think in other provisions, it also says that the employment shall be on a part-time basis. And under letter D of section 54, reemployment seems to connote that it's just that period when the elderly worker is still under the special apprenticeship agreement. So I am not quite clear whether after that agreement, after going through the apprenticeship, the elderly can actually be employed as a regular employee. It's not very clear to me, Mr. Speaker.
Yes, Mr. Speaker, the definition provides that there will be re-employment if an elderly worker who is covered by a special apprenticeship agreement in an approved industry for a special apprenticeship. In this case, Mr. Speaker, the special apprenticeship pertains to elderly workers, Mr. Speaker. So it's different from the question a while ago, the regular apprenticeship program. So this is another category, Mr. Speaker, a special apprenticeship agreement.
Yes, my question earlier was also about special apprenticeship of elderly workers. It's the same, Mr. Speaker. My question is really whether after the elderly worker completes the special apprenticeship and the agreement has lapsed, okay, can the employer hire the elderly worker as a regular employee? That's the first question.
Yes,
And
Mr. Speaker, we agree that it can be had that situation where the elderly worker will be hired by the employer, Mr. Speaker.
okay. Okay, I would like to move on to section 60, which covers working children. And here we're talking about administration of the income of the working child. Okay. And in section 60, the last part refers to the family code, saying that the administration, I guess, of the property or the income of the child as a consequence of his or her work will be under the parental authority. And then it makes reference to the family code. Do we want to also include the Code on Muslim Personal Laws, considering that there are Muslim children who may fall under this provision?
Yes, Mr. Speaker.
So it's the Family Code
We
or
will,
the
or
Code on Muslim Personal
maybe in
Laws?
this case, since this is a, yes, it should not be limited only to Muslim personal code, considering that there are non-Moro or non-Muslim residents in the Bangsamoro.
Considering that there are Muslims
And
in
there
the
are
Bangsamoro,
Muslims, Mr. Speaker.
because the Family Code is already there. Okay. Okay. And I'd like to move on to section 65. And this pertains to domestic workers. This chapter, chapter 4, has only one provision. And the same provision only makes reference to Republic Act 1053-61, which is a law on the welfare of domestic workers. Does this mean that, again, we are relying on a national law to define the rights and benefits of domestic workers in the Bangsamoro?
Yes, Mr. Speaker, as it's very clear in that section.
Yes. Then I make the same observation, Mr. Speaker, as in other provisions. And my concern is that we are not exercising the rights that are the powers that are already given to the Bangsamoro government, when it says that labor is one of the powers which the Bangsamoro government, the BARM, can exercise.
Yes, Mr. Speaker, we are amenable for any proposed amendment.
Okay. Let's go to informal sector workers, and specifically on section 68, which talks about unemployment transition assistance. Okay. Here it says that the informal sector worker shall be entitled to this assistance, to this employment transition assistance, in the amount of 2,000 pesos for 2 consecutive months. And the idea is the informal sector worker will get such assistance until that person has found gainful employment. So I think the direction is to move the informal sector worker from the informal sector to the formal sector, which means formal employment. And when we look at the formal in sector workers, these are enumerated in the provision before section 68, no? And that would include farmers, fishers, traders, etc. So are we saying now that we will no longer need farmers and fishers because we all want them to become formal sector workers?
Mr. Speaker, the section does not necessarily provide for that. What was mentioned was gainful employment. Gainful employment can be both in the formal or informal sector. Does not necessarily follow, Mr. Speaker.
But you can infer from the first part of section 68 that the purpose of the ETA is so that that person can find gainful employment. And when we say employment, that's usually in the formal sector.
We
There
do not
is no
agree, Mr.
employment. It's more of livelihood when we talk about informal sector economy.
We do not agree, Mr. Speaker, because gainful employment means you are gainfully employed. You're employed, Mr. Speaker, in whatever capacity, informal or formal. So that cannot be inferred in the said provision, Mr. Speaker, that we are trying to move away from all these people from informal to formal sectors.
So I think there's a need for a listing on this of
either a
what it-
listing or a clearer provision, Mr.
Yes.
Speaker, because when you say gainful employment, And that is even in the programming of government, that when you provide for livelihood, it's usually a micro business or employment. And employment refers to employment, meaning you are an employee of
An employer.
an establishment. Yes, Mr. Speaker. So maybe we can clarify section
If they can
68.
supply the proposed definition in due time, Mr. Speaker, we are amenable, Mr. Speaker.
But if the concept is already agreed, then that would be the next step.
Yes,
So
Mr.
the
Speaker,
idea is not to bring them all to formal employment.
Mr. Speaker, that's the idea, not to bring them all.
What
And
happens
not
if
to bring them,
the
Mr. Speaker.
informal sector worker is not able to get employment?
It is clear in the provision that the provision for ETA is only for 2 months, Mr. Speaker.
And thereafter, if that person does not get that gainful
The
employment,
ETA provides only for 2 months, so it necessarily follows that the said amount will no longer be supplied, Mr. Speaker. It's only for 2 months.
will there be assistance provided to the informal sector worker?
The
in
assistance,
getting that,
Mr.
not
Speaker.
the financial assistance, but to facilitate
Yes, Mr.
the-
Speaker, we may be we are allowing any proposed amendment for any other form of assistance, maybe from MSSD.
or maybe from MOLE.
MOLE has already provided. Maybe we can provide other forms of
No,
assistance
because it
from other
talks-
agencies.
Because
Mr.
it talks
Speaker.
about gainful employment, no, which is within the mandate of MOLE. Do we have, anyway, later in the costing? Okay, can we now go to book 2, which is on standards and productivity, hours of work? In under section 76, there should be meal periods that will be provided by the employer to employees, and this should not be less than 60 minutes. These are for meals, and can we be clarified what meals we are referring to?
Sure, I believe that this is lunch period wherein they're provided 60 minutes or 1 hour off. So
Okay.
it can be lunch or probably dinner, whichever, because sometimes there are night workers. So it falls on dinner time.
The
It's,
last,
daytime.
okay, I asked because in the last sentence, which is something new, no, which we do not find in the National Labor Code. It says that the meal period shall be observed within the allotted prayer time. Would that, what about afternoon prayers, for example?
Mr. Speaker, we submit that this should be not included in this provision because it is unduly constraining the exercise of that right for prayer time and the meal period, Mr. Speaker.
So are we saying that the last sentence should
The
be
meal
taken
period,
out?
yes, Mr. Speaker, shall be observed within the allotted. Maybe we should just take that out of this section, Mr. Speaker.
Okay. Okay, I think the provision also allows the employee to have a flexi time under section 79 and maybe other provisions. Will that answer the question of no, hindi rin. When is flexi time allowed?
Yes.
Kailan po pinapayagan ang flexi time?
Mr. Speaker, flexi time are allowed sometimes by the employer if the employee wants to go, like for example, in the Ramadan, the employer are allowed to go home early, like 3 p.m.
So it's not a permanent arrangement because under section 74, it talks about cases of, well, when there is a valid or a valid case, I guess, or if it's an emergency. So it's not a regular arrangement for flexi time.
Yes, Mr. Speaker, it's on a case-to-case basis per employer or employee. Sometimes the employer issues guidelines on that matter. Those who want to go early, like 7 a.m., they can go home at 4 o'clock in the afternoon. Those who wants to go to the office at 8 o'clock, they can go home at 5. Those who wants to go at the office at 9, they can go home at 6. Those are flexi time, Mr. Speaker. It's on a case-to-case basis sometimes when it's requested by the employee.
Okay. Will the employee who has requested for flexi time and who has moved the working hours such that the work will go beyond 6 p.m. Will that person be entitled to night shift differential as provided in succeeding provisions?
In this case, it's a flexi time that are requested by the employee. If it's the employee who wants to work on that particular day beyond 6 o'clock, 6 p.m., what do you mean? If the employee wants to go at 10 a.m. and then goes home at 7, will he be? May I be clarified, Mr. Speaker, because the question needs clarification.
That's the question, Mr. Speaker.
So in that case, Mr. Speaker, we submit that the employer has the discretion to discuss with the employee because it already falls with the night shift when it already goes beyond 6 o'clock.
And there is a national law governing that system or time of work.
Well, Mr. Speaker, I would like to put that in the discussion on whether we are saying that national law will still apply even if we have already enacted our own labor code.
Speaker, the labor code that we have we are trying to pass, Mr. Speaker, are our own labor laws that we are going to codify that is within our authorities. As for the other matters that we refer to the existing laws, it is very clear that by incorporation, we want those laws to be included in this labor code, Mr. Speaker. And I don't think there is a clash because we have tried to harmonize those provisions, the labor code, the Bangsamoro, the PD 442 as amended, and the Bangsamoro labor code.
Okay. But the idea of codifying is to put together all laws that should apply in the Bangsamoro Autonomous Region. And we should be careful in ensuring that all the laws, whether it's provided in a national law or something new, should be included in the labor code. Because that's the power already granted to us. Anyway, like to look at section 80. And this is on emergency overtime work under paragraph A. It talks about the one of the instances when an employee may be required to work overtime. And that provision, that paragraph says that when the country is at war or when there is a national or local emergency as declared by the president. Can we be enlightened on this? Do we not contemplate the declaration, for example, of an emergency or a declaration of calamity, for example, in the region by the chief minister? should we limit it to the declaration or the declaration by the president of a national or local emergency?
Speaker, we yield to that proposition. Declared by the Chief Minister.
So instead of the president, it will be the chief minister.
Speaker, it can be declared either by the President if it's a national emergency or the Chief Minister if it's a local
Local.
emergency.
Okay, can I move on to section 94, Mr. Speaker? And this talks about a seasonal incentive, saying that all employees shall be entitled to 1,000 pesos seasonal incentive. Maybe be enlightened on what this incentive is about.
Mr. Speaker, seasonal incentive, as the word says, it's seasonal. Maybe it's during Christmas season or other holidays, Mr. Speaker, the employee. So there are so many, Mr. Speaker, seasonal incentive, subject to the employer's generosity and availability of funds.
What other seasons are there?
Maybe we will put a listing of the seasons that I think this does not unduly limit the employee to just a regular season like Christmas or other holidays, Ramadan. So we should not probably put the listing here, Mr. Speaker.
In the, may I butt in the National Labor Code, the listing is fixed.
Okay. Is there no qualification in that provision? It says all employees.
Yes, Mr. Speaker, the question was, is there a qualification?
Qualification
Qualification as to the type of employee?
as to who are qualified. If you have, for example, been employed for only 1 month, because
No
it's
qualification.
it's a very general statement, and it's not even clear what seasons mean here. Maybe we can look at how we can make a clearer provision that will show the intent of the legislators, Mr. Speaker.
Speaker, we yield that it should be subject to guidelines by the MOLE.
And maybe even the law itself can be clearer as to the seasons, because I believe it's not just me who wouldn't know that Christmas is a season or that there are other seasons aside from winter, spring, summer, and fall.
Yes, maybe we can fix this to all employees, whether contractual or otherwise, or regular employees.
Okay. As to section 113, and this is on cultural rights and practices, on prayer breaks, it talks about a 1 hour break, no? During holidays. We all know that the prayer times for Muslims, that there's more than one. And it's not just on a holiday or a Sabbath.
Maybe no, Mr. Speaker, the section that we are discussing.
This is on prayer break, section 113.
Mr. Speaker, maybe it's 123.
113,
118.
prayer break.
Tingnan mo nga.
Employees shall be
125,
excused in
Mr.
their
Speaker.
work, section 113.
Mr.
Wala ba?
Speaker, we have the code here. It's 125.
Section 113, prayer break.
Mr. Speaker, the question, please. The question is,
And the question is, it provides that that the employees shall be excused for at least an hour and on applicable holiday in a week. Will that mean
Friday.
that, what about the other prayer times? How will the employer treat the praying of Muslim employees during,
This refers to the Jumu'ah prayer.
I believe that that's for the Jumu'ah, Mr. Speaker.
and what
Why
about,
not just provide that the employer can have some incentive if he closes during prayer time on Friday prayers instead of just giving 1 hour of prayer time for Muslims.
Mr. Speaker, there might be situation where there are only few who are Muslims in the employment. So if the employer closed the business, like
We will take that into note, MP Raisa.
what about section 114? It talks about call for prayer. I'm not very clear whether that covers the actual praying of the employee.
Mr. Speaker, it talks about the adhan, or in other religion, they might have a
Okay. So,
different call for prayer.
so the actual prayer itself, how will the employer treat that?
Yes, Mr. Speaker, we are amenable for a amendment, considering that for Muslims, there are 5 times a day prayer.
Um, for section 116, it's about pilgrimage. For Muslims, that would be for Hajj. Is that correct, Mr. Speaker?
Mr. Speaker, it doesn't pertain only to Hajj. There are also pilgrimage by non-Muslims.
As I said, if for Muslims, this would refer to Hajj.
Yes, Mr. Speaker.
Will it cover optional pilgrimage? And for how many times can the employee avail of the pilgrimage leave? Can that employee ask for pilgrimage leave every year, for example, if he or she has the resources to do so?
I think, Mr. Speaker, we need to clarify this provision, because if the every year we allow the pilgrimage leave to be had, then that might not be good for the business of the employer.
Yes, is this on top of the national law provisions on leaves?
Mr. Speaker, it's not, it's very specific to pilgrimage. So we believe that for further clarification, we will put a limit on this as one time.
Yeah,
Privilege.
that's why the title should be Hajj and other pilgrimage leaves.
And whether it will also cover Umrah?
Mr. Speaker, that's 30 days, meaning if it's an optional Hajj like Umrah, or the bigger Hajj like the Hajj Mabrur, or the bigger Hajj, then we believe that it's just 30 days. That will be
Well-
exercised, that will be allowed by the employer. For the next succeeding Hajj, then that would be subject to the leave credits.
But if the employee does not go into Hajj, the mandatory one, but applies for a pilgrimage leave for Umrah, will that still fall under section 116?
Yes, Mr. Speaker. It depends on the employee what pilgrimage he or
So-
she would
So
choose.
it can cover both Hajj and
Yes,
Umrah.
any pilgrimage, but as long as the employer is only allowed to employees entitled only for 30 days, Mr. Speaker. I believe
Yes.
that's already for
Yes,
the
that's-
jury employment.
Yes, but as I said, the employee may choose not to go on Hajj, but can go on Umrah.
Mr. Speaker, so any form of
Yes.
pilgrimage.
Basta it's within 30 days. Okay.
There should be a listing on this.
Can we go to section book 4 and specifically section 121? Just to be clear, again, I raised this matter because it talks about Bangsamoro workers. The we may have to be clearer on this because there may be workers who are residents of the Bangsamoro region but who may not ascribe to the Bangsamoro identity. And I believe the intention is to cover them, no? Under this law also.
Mr. Speaker, there's the book that we are holding is the latest one. So I am very confused now. What page are we talking about?
Section 121, it's flashed on the projector.
Mr. Speaker, the question is,
It talks about Bangsamoro workers. I'm saying that we may have to be clearer to make sure that workers who are residing inside the Bangsamoro but who may not ascribe to the Bangsamoro identity covered by this law.
workers who are working within the bank. Yes, Mr. Speaker, we yield to any proposed amendment.
I will now go to section 136 on the allocation of maternity leave credits. Again,
What section is that?
136, Mr. Speaker. And this makes reference to RA 8187, which is maternity leave. So under this I think there is a provision, I'm not very clear, but under the labor code, while RA 11210 has been incorporated under section 136, there, sorry. So it's in section 140, paternity leave. But still, my question is the constant reference to national laws. If we are codifying the labor code, I think we should incorporate the relevant provisions of these national laws, which we want to implement inside the region. Okay. Okay. I'd like to be clarified on section 143, which is special leave benefits for women. May we be enlightened as to what kind of cases would fall under this? This talks about getting benefits for women who undergo surgery caused by gynecological disorders.
Yes, Mr. Speaker, it talks about other disorders other than maternity of giving birth It also
such
talks
as
about of hysterectomy,
mm,
ovarian cancer, tumors, and any other gynecological disorders, Mr. Speaker.
this would be over and above sick leave benefits if the
Yes, Mr.
employee
Speaker.
has
It's
those.
over and above the sick leave benefits. I believe in the government, we also have this kind of leave. We are entitled also to 2 months. If
Yes,
there's-
and this is also over and above the pilgrimage leave.
Yes, Mr. Speaker.
As to section 148, which is on female quarters. Is this 148? Is this true even for employers that do not
Mr. Speaker, it is true for employers not having night work.
may we know the rationale for this provision?
We submit that this beneficial for women to have their own quarters if the women are more than 50 in a business or
And
Employer.
they are not required to work at night?
yes, Mr. Speaker, this is probably for privacy and other purposes, Mr. Speaker.
Will a lavatory not suffice for private activities?
Mr. Speaker, I don't think that because this provision are actually from our consultation with women and especially the ulama group.
What would be inside the quarters? If I may ask, Mr. Speaker.
It's a space exclusively for women, Mr. Speaker. We do not know what kind of provision, if they're going to have air conditioning,
Will there be
furnitures,
beds?
but we mentioned quarter, Mr. Speaker, so it depends on the capacity of the employer. But the law itself will provide for a separate quarter for women to observe the hijab, the separation of men and women, especially for those who clamor for that in the public consultation.
Do we also have a space allocated for prayers
Yes, Mr.
in the
Speaker,
provision
in
uh,
158.
158? Sorry.
Iba na yung tago sa kanila. Bakit mo magkaiba tayo sa kanila?
Anong section po?
There's a
158?
prayer space, Mr. Speaker, for employer for at least 10 employees.
Okay, what section? Sorry po.
The secretariat is ordered to look for the prayer
Chapter
space.
5, under Chapter 5.
Chapter 5.
That's facilities for women, Mr. Speaker.
Prayer break, prayer space, dress code.
Prayer space, meron?
In the cultural rights, there's a prayer space.
And did we say that there would be a separate space for women? It only talks about 112. It talks about prayer space, but
Mr. Speaker, the prayer space under this section does not contemplate separation. However, the employees and the employer can actually determine what spaces are for men and women, considering that under Muslim laws, the prayer space for women are really separated from men. So it might be in the same room, but there's a curtain separating them.
yes, because we indicated that there should be female quarters. But in the prayer space, we did not make a provision for the separation of spaces. Anyway, we can review that later. Okay. Okay,
Speaker,
under,
maybe we can enhance further this. We are open for the enhancement.
okay. I will now go to section 152, the right to disconnect. And may we hear from the proponent how this will operate? Will this also apply to government agencies?
The labor code only applies to private, does not apply to government agencies.
Not
Civil
really, Mr.
service law
Speaker.
apply for government.
Yes, but there are parts of the
employees.
labor code that apply to government employees.
So
And we've gone through some of them.
I believe, Mr. Speaker, the labor code as amended does not apply to government employees. The civil service rules and regulation governs employees of the government. So they cannot provide for government employee regulation here, especially in this section, because that would be violating our existing laws on civil service rules and regulation, including the civil service laws that we have already enacted.
Yes,
the
but
Bangsamoro
there are also
Civil
provisions.
Service Labor Code.
There are provisions on government internship program that's in the labor code. So there are parts of the labor code that are applicable to government employees, Mr. Speaker.
Sir Speaker,
There's also Title 4 on
the
public
government
service.
internship program is a regular program of MOLE. It's not a civil service regulation. It's not a civil service regulated program.
There's Title 4, Mr.
The-
Speaker, it's clear, public service workers,
The public service
public
worker,
sector workers. So there are parts of the labor code, Mr. Speaker.
I think it's clear that there are parts of the labor code that are applicable also to the government employees.
yes, but there are limits, Mr. Speaker. And when we talk of labor code, I believe it really pertains to the regulation of the private sector.
Yes, and I'm asking whether 152 will, what is the intent, and will this also cover government employees?
No, Mr. Speaker, Section 152 is for private employers. And if the civil service so sees in its wisdom, they can adopt their separate rules for Section 152, provided that the civil service shall issue regulations that adopts this section. But absent that, I don't think we can enforce it to the civil servants.
Section 157. Sorry, no. Wait. Sorry. Okay, I will go. So for example, Mr. Speaker, Section 161 is the right of employees in the public service. There's in the counterpart provision under the National Labor Code, there's a last sentence pertaining to employees in the civil service having the right to form associations. And this is not included. That sentence does not appear in Section 161. So let me read that sentence. All other employees in the civil service shall have the right to form associations for purposes not contrary to law. Maybe no, if there is a reason behind the non-incorporation of that sentence to Section 161, because it talks about the right to form associations, Mr. Speaker.
Mr. Speaker, the provision pertains to government-owned and controlled corporation that are organized under the Corporation Code. So technically, Mr. Speaker, they are treated like a private employees. So they shall have the right to organize and bargain.
But the title, Mr. Speaker, is
Yes, Mr.
on
Speaker,
public service.
we will yield to any amendment to make it further clarified that this only applies to GOCCs.
So there is no distinction between those employed in a GOCC and in a private corporation.
Yes, Mr. Speaker, because under they are incorporated under the corporate code, Mr. Speaker, so they are treated like private employees, Mr. Speaker. They are governed by their charter.
Um, Also in the right to participate in policy and decision-making process. I believe that in the counterpart provision of under the National Labor Code, that right is contextualized. It talks about policy and decision-making processes that directly affect their rights, benefits, and welfare. Well, it's there affecting the rights and benefits, but it also talks about the process, and the process is through Labor Management Council, and this does not appear in section 162. Is there another process that the proponents wish to institutionalize in the exercise of the right to participate in policy and decision-making processes?
We are amenable to any amendment on that matter, Mr. Speaker.
I think I skipped some parts, and this refers to labor relations. I understand, and I will have to go find the specific provisions. My reading of the bill is that we have deleted or not incorporated. We did not incorporate in the bill processes for registration or affiliation, registration of or affiliation to national federations and unions. Is that a deliberate design in the bill? Do we not allow national federations or national unions to
Before you pursue that question, MP Raisa, ineligibility of managerial employees to join labor organizations. Is there no labor organization for managerial employees only?
Yes, there can be one, but they are not entitled to join the supervisory employees and rank and file.
Yes, I
Organization.
think that
They're
this is
separate, Mr. Speaker. They
yeah,
can form
they
and
have
organize.
their own.
Yes,
So
Mr.
you
Speaker.
cannot put this in this provision. That should be clarified because they can join labor organizations of managerial employees also within the same workplace.
Yes, Mr. Speaker. So if there's an amendment to that effect, we will allow that, Mr. Speaker, to further clarify section 163.
Mr. Speaker, I think we can review that further because from my reading of the law, managerial employees they represent the employer and therefore they cannot be part of labor unions. Rank and file employees are allowed to organize themselves into unions. Same with supervisory employees, but they should not be part of the rank and file employees union. For managers, if you look at the definition of terms, they are categorized as, or they carry the interest of the employer, Mr. Speaker, and therefore they are disqualified from forming unions.
I'll take note of that.
Saan na ba tayo? 1-6. I go back to my question. Are in the Bangsamoro, when workers organize themselves into unions, one way of doing that is to register yourself as a labor union. The other way is affiliating yourself to a federation, which already has a legal personality as a labor organization. In the National Labor Code, labor unions are allowed to affiliate with national federations. But I observed that in this bill, with that those portions of the National Labor Code have not been incorporated. Are we saying that we will not allow labor unions in the Bangsamoro to be affiliated to national federations? Or the other way of saying that it is national federations cannot operate or cannot recruit member unions from the Bangsamoro region.
Mr. Speaker, in the labor organization registration, they're allowed, Mr. Speaker, to join federation.
I will go back to those
Chartering and
provisions.
creation of local charter.
Anong section nga po? Sorry.
Please go to chapter 2
Section?
because I will give you a different section because the one that was given to me is chapter 2, Mr. Speaker.
Chapter 2 of what book?
Chapter 2, labor organization. Yan
Because
po.
there's
Sa baba niyan. Sa baba. Just the next
161,
section. That one.
166.
167.
Sorry. Okay. In the National Labor Code, the equivalent provision says a federation, national union, or et cetera, et cetera. Here in 166, there is no option to be part of a national federation. Under 167, there's a federation or regional union. My question is about national federations. So these are the likes of Federation of Free Workers and the like. So are we saying that we want regional federations only? And we are excluding national federations in the BARM?
Mr. Speaker, there is no prohibition in the Bangsamoro Labor Code draft for them to join. In fact, there's also another section, requirements for registration of federations.
Yes, federations are okay.
But there's no prohibition for them not to join.
Then maybe we can be clearer on this. Okay, I will go to section 176 on foreign assistance. How will this relate to the BOL provision on the receiving of grants and donations?
Speaker, what's the question? Are they-
Section 176 on foreign assistance, which allows which mandates the Minister of Labor to promulgate rules on the receiving of donations, foreign donations. How does this relate to the provision under the Bangsamoro Organic Law regarding receiving of grants.
Mr. Speaker, this is about the labor organization or employers organization receiving grants. So the MOLE, in accordance with the Bangsamoro Organic Law, shall
they are
provide
allowed.
guidelines.
Okay. Pero government.
We will have a break for 15 minutes
Okay.
so that the
Thank you.
other members can take their asar prayer. Session suspended for 15 minutes.
Kan.
We will now continue with the ongoing interpellations on the proposed Bangsamoro Labor and Employment Code.
Mr. Speaker, I'd like to go to section 194. And I guess my comment here is not really just for that specific section, but for the whole labor justice system that's being proposed under this code. Because right now, based on my reading of the bill, there would be Bangsamoro Industrial Peace Councils, the Bangsamoro Conciliation and Mediation Board, the Bangsamoro Labor Adjudication Commission, the Bangsamoro Labor Relations and I guess standards. Not exactly sure. There are so many different entities tasked to to receive issues, complaints, either from the workers or from the employers. Maybe know if there is a difference between what is already installed in the national level and that which is included in this code. And if we can be shown like an organogram showing the delineation of functions of these different entities and how they relate to each other, if there is such a relation, and also how they relate to national agencies and courts, if there is such a relation.
Yes, Mr. Speaker, we will do that, Mr. Speaker.
Because, Mr. Speaker, I think the one of the advocacies of different stakeholders working on labor and employment would be to simplify the structure for addressing issues and concerns in relation to labor and employment. And this is the opportunity to do that. Since at the national level, it's very hard because there are already national laws establishing these bodies. In the BARM, we have a clean slate and we can work on a simplified and a more efficient structure that would address labor justice. So we thank the proponent for responding to our request. Maybe at the next session, we can be shown the structure. Okay. Let me go to post-employment, section 206. And this refers to probationary employment. In the counterpart provision of the labor code, there is a sentence that says that an employee who is allowed to work after a probationary period shall be considered a regular employee. But I do not see that in section 206. Is there a reason for not including that? I think it's an important provision because it says that if you pass the probationary employment period and you are not terminated because you did not perform well, then you should be considered a regular employee automatically.
Yes, Mr. Speaker, Section 207 in fact prohibit labor-only contracting parties. We are amenable to any amendment to the effect that putting a number of months, like 6 months, after 6 months, you are already considered for permanent employment.
Okay, thank you, Mr. Speaker. H and G. We just like to also flag section 224, which is on recovery of wages, simple money claims, and other benefits. I think we need to review how we formulated it because in some parts we still refer to the Department of Labor. Not sure if that is the intention or if that was just an error. Meaning we should be referring to the Ministry of Labor and the Secretary of Labor instead of the department. The ministry and the minister instead of the department and the secretary. That's in 224.
Speaker, we submit.
Sige, my other questions would be all related to the structure and the mandates of each of the different structure mechanisms to address labor issues. And I guess one question I would like to pose in relation to that bigger question is how adjudication was made under the time of the ARMM when powers over the matter of labor in the autonomous region was limited, and who exercised this power and how many personnel were devoted to this task of adjudication, conciliation, mediation.
Mr. Speaker, during the time of ARM, is that the question? We have a resource speaker here, former Secretary Jaquilan of Dole, of Labor, of ARM.
Mr. Speaker, may I,
You're recognized.
in the previous Dole arm, the only adjudicatory agency we have was the mediation board, mediation arbitration board. And most of the cases filed with Dole were settled through SENA, single entry approach. And when cases are to be elevated to higher ups, they go to the regular national agency, the NCMP. National Conciliation and Mediation Board. Did I answer the question?
Mr. Speaker, may I be clarified whether the NCMB that he is referring to is, where is it located at the national level? Sa
Yeah,
national,
it is a national office.
but physically it's in region, is there a
We
regional
have
NCMB?
all regions, they have their NCMBs.
So there's a region 12 NCMB. So is that where cases are lodged?
Yes po.
Okay. I think that's telling of how limited the structure and the powers and maybe the funds, no, for addressing labor issues in the ARMM. And we are at this point, we have this opportunity to design our own structure for labor justice. But looking at what is already provided in the bill, and there are so many different bodies, many of them, if not all of them, are counterpart bodies of the national structure. No, BILAC is NLRC, BCMB is NCMB, and so forth. No. First, I'd like to know if there is a computation of the estimate cost for creating all of these structures. If there is. Meron po ba? With 3 arbiters and 3 sub-regions, magkano po kaya ang gagastusin natin?
So,
If,
Not yet.
if there's an estimate, Mr. Speaker. Wala pa.
wala pa po, Sir Speaker.
So it will be created after the passage of this law.
Yes, but in this law, we should be able to state how much we are allocating. So I'm asking whether the figure is already ready, if there's an estimate, but I guess there's none. But my other question is whether we are open to looking at these structures and proposing alternatives that will be simplified, more accessible to those who would want to use them.
Yeah, yes, Mr. Speaker. We have no competition, Sir Speaker, but meron tayong salary grade, different salary grade of the personnel.
Of certain positions,
Yeah,
pero
certain
not
position.
the administrative rank and file employees, no? Wala pa po
Yes, po.
tayong ganito. Hindi po. And you are amenable, Mr. Speaker, we are asking the proponent if they are amenable to exploring how to simplify
yes.
the structure.
Yes, we amenable, Mr. Speaker.
Okay, thank you, Mr. Speaker. One last point. Under Chapter 3, the Bangsamoro Conciliation and Mediation Board, there's reference to regional interest cases. Can we be clarified what these are? Regional interest cases. Sana ba yun? It's in the last paragraph.
Can you repeat the question?
The regional interest cases referred to under section 241, because it's a very long sentence, but it talks about the exclusive and the original jurisdiction of the BCMB. And in that paragraph, is included these regional interest cases.
Yeah.
Ano po kaya yun?
Are you finished with the labor, the commission here?
Yes, I'm already in the Bangsamoro Conciliation and Mediation Board, Mr. Speaker. It's in section 241.
Mr. Speaker, the regional interest cases is akin to national interest cases. So if there is national security issue, the labor cannot stop. There are instances where if there are, like for example, disaster, the employer cannot stop producing a particular item that is very essential for recovery. So that is also akin to the regional issue when there are regional interest cases happening.
Okay, because that I don't think I see the same or a similar item in the jurisdiction, original jurisdiction of the NCMB. That's why I was asking about this. Anyway, last na lang po talaga. Sa transitory provisions, Article 248, it says here that the Ministry of Labor shall submit annual reports. Is this a public report or will it be submitted to the Parliament or any specific agency of the government?
Speaker, it's the Parliament that would be needing that report.
Maybe we can just insert that to be reflected in the language of Section 248. I have no other questions, Mr. Speaker. I will reserve the right to introduce amendments at the proper time. Thank you, Mr. Speaker.
Welcome.
Thank you very much, Mr. Speaker.
The lady from Maguindanao, MP, the Deputy Minority Floor Leader by Intan Pampatuan, your time is up. Are you ready for interpellation now? To interpellate?
Mr. Speaker. Hello.
We cannot hear you.
Hello.
Yeah, you may proceed.
Yeah, Mr. Speaker, thank you very much. Actually, I'm still in the middle part of the review of the draft labor code, Mr. Speaker. But I guess there are a lot of interpellators that are on the list. Maybe I can introduce or share my first part of my interpellation, Mr. Speaker, so that I would be given enough time to finish the review from page 50 to the last page, Mr. Speaker. Mr. Speaker, before I go into the details of my interpellation, I would like to ask some housekeeping questions, Mr. Speaker. First, Mr. Speaker, is that this is a private member bill, Mr. Speaker, and principal author was the former Minister of the Ministry of Labor and Employment, Mr. Speaker. My question is that during the time of the crafting of this code, Mr. Speaker, was there a chance that this code was presented to the cabinet, Mr. Speaker? Hello.
Yes, Mr. Speaker. It
So,
was referred to the cabinet. It was March.
so it was presented to the cabinet and it was discussed in
But
the cabinet.
Unfortunately, Mr. Speaker, hindi po na-discuss in the cabinet, hindi po na-deliberate for 4 months. So that's why the committee was decided to convert into a committee bill.
So it was not discussed in the cabinet, and therefore it was referred to the committee, and it was decided that it was a committee bill.
Yes, Mr. Speaker.
So this is a committee.
Yes,
Um,
committee bill.
Yeah, may we check with the secretariat the records of this bill as to whether or not was a private member bill or a committee bill.
Committee bill.
we need to determine that, Mr. Speaker, because my second question is the bill certified as urgent by the government of the day?
Yes, Mr. Speaker, it's a part of the priority bill of the government of the day, Mr. Speaker.
My question,
Priority bill.
Yeah, Mr. Speaker, my question is this certified as one of the priority bills of the government of the day? And if so, Mr. Speaker, what documents would attest that it was certified that it is priorities?
Hindi po wala pong written certifications urgent bill, but during the summit, during the Bangsamoro Labor Summit, Mr. Speaker, the chief ministers stated that the government of the day is one of the committee pushing for the fast track and for immediate and fast track passings of this bill, Mr. Speaker.
Thank you very much, Mr. Speaker. I need to determine that, Mr. Speaker, because the bill is very lengthy, Mr. Speaker, and therefore we actually need time, especially the lawyers, to really review it, Mr. Speaker. But given that it's one of the priorities of the government of the day, Mr. Speaker, I think it's but proper to fast track it, if that is, Mr. Speaker. But we need to ascertain that, Mr. Speaker.
With due respect, with the good MP Engineer Baintan, Mr. Speaker, this proposed bill is gone through the legal and democratic processes within our procedures, Mr. Speaker. Yeah, this dumaan po siya sa this is Mr. Speaker, until or the consultants, and also to when the International Labor Organization, Mr. Speaker, in Bangkok is already na-review din nila ito, Mr. Speaker, itong labor code natin, which called it's compliance with the International Labor Convention, Mr. Speaker.
Thank you, Mr. Speaker, but I'm not saying na hindi po na-review, no? And I'm not saying na kailangan nating i-delay, Mr. Speaker. I have to be very clear on this, Mr. Speaker. What I'm ascertaining is that is this bill part of the priority bills of the government of the day? Because if this is part of the priorities, then we need to fast track, Mr. Speaker. That's my point, Mr. Speaker. Now, moving on, Mr. Speaker, on the bill itself, Mr. Speaker. We know that there are laws, no, labor laws, existing national laws, governing laws on labor and employment prior to the Bangsamoro labor and employment code, proposed code, Mr. Speaker. My question is that I know that this has gone into a substantive consultations, but my question, Mr. Speaker, is that what are the laws that have been reviewed in crafting this labor code at the Bangsamoro?
Yes, of course, Mr. Speaker, the Bangsamoro level, our legal basis of this proposed bill, Mr. Speakers, one is the uh, Labor Code of the Philippines, and of course, the Republic Act 11004 and the Bangsamoro Autonomy Act 13, Mr. Speaker. That is our legal basis, Mr. Speaker.
So yung tatlo pong major documents, yung
Yes,
labor code,
Yes, Mr. Speaker, although we reviewed the labor code, the employment code of Malaysia is also our reference, Mr. Speaker.
okay. Thank you, Mr. Speaker, for that information. In a nutshell, because this is a code and this is a compilation of existing laws and regulations governing labor and employment, Mr. Speaker. Would you have an idea? Estimate lang, mga ilang percent yung coming from the national law that we have adapted in crafting this code of the Bangsamoro, labor code of the Bangsamoro?
Actually, Mr. Speaker, is substantially consistent with the national labor law, Mr. Speaker.
So when we say substantially, it could be 70 to 80% of the national laws being adapted in this code, Mr. Speaker.
Mr. Speaker, may I recognize Brother MP Sayodja, our co-authors, to answer that.
You're recognized.
Okay, Mr.
Thank you, Mr. Speaker. As regards to the question of MP Engineer Baintan, we could not be exact with the percentage because we are not doing so, but we have substantial references and inferences with the national laws and that of the law of other countries, which we think and we are sure that are applicable to the Bangsamoro people who will be our workers as far as this code is concerned. So we are confident enough that this code shall it be passed by this August body. We are sure that this is a very reliable and valid law for the Bangsamoro. Thank you.
Thank you, Mr. Speaker. My next question then is if we take substantial portion of the national laws and considering other international laws. My next question, Mr. Speaker, is that what could be the major difference or differences of this code with that of the national code, Mr. Speaker?
Yes, una-una, Mr. Speaker, this proposed law is in the context of the Bangsamoro promulgated to provide a framework the aspirations and needs of the Bangsamoro workers, Mr. Speaker, reflected on the cultural and traditional of the Bangsamoro workers, Mr. Speaker. That's the big difference, Mr. Speaker.
So yung cultural...
Mr. Speaker, MP Udsa, allowed to add the...
You're recognized.
Thank you. Along that inquiry, we are not so particular of that of differences with the national law, but we are sure of the principle of consistency with the national law is recognized and applied here. And of course, national law applies to national level, including all Filipinos. And this law is intended for the Bangsamoro workers. But we are sure this does not run contrary to the national law, the National Labor Code. Thank you.
May I butt in? Are you saying now that in the passage of this law, the Philippine Labor Code will no longer apply to us?
We are not, Mr. Speaker, we are not saying that, but preference-wise, we apply this law, shall it be passed, but in consideration as well of the compliance to the national law, much more for the Constitution of the Republic of the Philippines.
Mr. Speaker, actually, my question would read down to what are the advantages of passing this law, given that there are already existing national laws, comprehensive at that, and even international laws on labor, Mr. Speaker. What are the advantages so that we would appreciate it very much that we have this particular code in the Bangsamoro, Mr. Speaker? What could be the highlights and advantages of having our own labor and employment code, Mr. Speaker?
Yes, Mr. Speaker.
Mr. Speaker, this question actually is not for me, and I just want the general public to understand why we are doing this, Mr. Speaker, and why we need this code, Mr. Speaker, so that the people would understand that we really need this particular code so that it would help the general public. So this is not for me, Mr. Speaker. This is for the public, Mr. Speaker.
Yes, Mr. Speaker, we understand the question. How are we going to be better off with the Bangsamoro Labor Code codification? We submit, Mr. Speaker, that the codification is really very important, considering that there are so many updates already, not just locally, but internationally under the International Labor Conventions, which we tried very hard to incorporate in this labor code. And in fact, the national representatives, undersecretaries who attended, said that this code would probably be a very important legislation that will be modeling what a code should look like in the national level. The participants of the latest labor summits, Mr. Speaker, are no less than congressmen and undersecretaries and former secretary ba yun sa labor summit, who said that the labor code of the Bangsamoro is much awaited by the national government because they want also to at least have an approximation on how they're going to update their labor code. And in fact, the labor code contains so many cultural rights and practices that are very unique to our situation as Moro or Bangsamoro.
So it's in the uniqueness of the culture that highlights the advantage of having this code, Mr. Speaker. Do you agree with me, Mr. Speaker?
May I ask this question? So you are saying that if we only pass culture related related provisions in the proposed code and allow the National Labor Code to apply to us separately to these culturally related provisions, it would be okay.
As a due respect, Mr. Speaker, of course, we are autonomous government. So meron tayong batas, sariling that Republic Act 1105, that was our principal guidance in our the craftings of this law, Mr. Speaker. Thank you. Mr. Speaker, I allowed Mr. MP Damna to say something.
The question there is, if we only pass culturally related labor laws and not touch nationally passed provisions of labor laws, would that be okay?
No, Mr. Speaker, the Bangsamoro Labor Code in all its completeness touches on so many different aspects, not just the cultural uniqueness, but also, Mr. Speaker, the jurisdictions of some of the agencies that is already within our authorities and powers. So we exercise now what we call the political autonomy, where we now define what Bangsamoro labor looks like in the labor code.
Baintan?
Well, I have yet to see those provision that talks about exercising the powers of the other agencies, Mr. Speaker, and I deal with it in the detailed interpellation, Mr. Speaker. But basically, the real question is, do we really need to pass this labor code if the major difference with the national government is on culture and Mr. Speaker, and practices, Mr. Speaker.
Mr. Speaker, una-una is the national government or the in the 11054 enumerated power. So those that enumerated power, one is the power on the labor, employment and occupations. So that's why itong labor code po natin is in accordance to that power that in the 11054. So
Yeah, we understand the powers granted to the Bangsamoro. However, the question there is, I believe that was raised by MP Baintan, is whether it is timely to pass a labor code that we are still in the process of institution building.
Yes, Mr. Speaker, it's a timely. That's part of the institution building, Mr. Speaker.
Yeah. Thank you, Mr. Speaker. Mr. Speaker,
Just
I'd
to add to MP Baintan, there is now a problem with regards to jurisdiction because the NLRC do not want to encroach upon the power of the Bangsamoro government with regards to labor. So they said, you already have your own powers. We will respect that. And now we are in a predicament because now our labor sector is in a quandary. May problema po dahil wala po tayong mga sinetap na institution para sa labor. So ngayon, that's what we're doing now. We're correcting that by supplying these institutions that will be now exercised by the government of the Bangsamoro.
Okay, thank you, Mr. Speaker. But again, this is a code, Mr. Speaker, and in the crafting of the code, Mr. Speaker, I know that there are provisions that we became selective, meaning to say there are provisions in the national labor code that we included in this Bangsamoro code, but we didn't included everything, Mr. Speaker. My question, in case the provisions that were not part of this draft code of ours is not included, Mr. Speaker, and there are issues that are related to it. What will happen to that particular issue, Mr. Speaker? We would refer back to the national code, Mr. Speaker.
Mr. Speaker, in the Republic Act 11054, Section 10, the Parliament may pass labor laws that expand or enhance the rights stated herein. So itong proposed law natin, Mr. Speaker, is to enhance and expand the power of the yes, Mr. Speaker.
Okay, in that case, Mr. Speaker, we need to be very cautious about that word expansion, Mr. Speaker, because the national law is a national law, Mr. Speaker, and we cannot go beyond the national law, Mr. Speaker. And I have yet to see the provisions that talks about the expansion of the powers given to us, Mr. Speaker. But Mr. Speaker, I will not labor on this, Mr. Speaker. But I would lay on the table that my basic question is, what are the advantages of us having our labor employment code? This is a very basic question that needs to be answered and needs to be communicated to the general public so that once we approve this particular measure, Mr. Speaker, the people would appreciate our efforts, Mr. Speaker.
We will do, Mr. Speaker.
Yeah, my basic question on that is if we pass this labor code, will it invite investors?
Yes, Mr. Speaker.
It will invite investors.
Yes, Mr. Speaker.
I am suggesting to the proponent, Mr. Speaker, that they put it on paper, all the advantages of having this code, Mr. Speaker, so that later on we can help in the communication, Mr. Speaker, because we are part of this parliament, Mr. Speaker.
Yes, Mr. Speaker. It's the advantage for the Bangsamoro, Mr. Speaker.
My next general question, Mr. Speaker, is related to the last question of MP Jajuri regarding the budget implication, Mr. Speaker. Because we are going to set so many structures and mechanisms. Given the right sizing principles and policies that are being adopted right now by the Marcos administration, Mr. Speaker, we need to be very precise in the crafting about the structures so that in the allocation of the budget, Mr. Speaker, we can easily defend, no? Because this would entail budget, no? My question, Mr. Speaker, is, was there a pencil pushing done by the Secretariat, just a rough estimate on how much does it cost the Bangsamoro in crafting its own labor code, Mr. Speaker?
Mr. Speaker, yes, we will abide by the request, Mr. Speaker, to put advantage and disadvantage in a paper format so that it will be part of the briefer as well as the allocation of authorities and powers of every offices that are mentioned in the Bangsamoro Labor Code.
Yeah, my additional question to that, was this referred to the Committee on Finance?
It's actually my next question, Mr. Speaker, because we are already here in the plenary, and I guess the next question is we need to defend this before the Committee on Finance, Mr. Speaker.
Mr. Speaker, we did not put any amount in the Bangsamoro Labor Code because it's enumeration of policies of the government as well as different offices that will be created. However, the amount, Mr. Speaker, we cannot approximate that. Maybe, Mr. Speaker, it will be subject to the contingent fund, but we were silent on the amount because we cannot approximate, Mr. Speaker, the amount that will be required to fund the offices that we have created.
May I ask this question, MP Baintan?
Mr. Speaker, wait lang. I beg to disagree, Mr. Speaker. I think before passing any law, we need to have some cost estimation of the resources that it would take the Bangsamoro government to allot for a particular law, Mr. Speaker, because our resources is not unlimited. Our black grant is depleting already, Mr. Speaker, so that it would require us really a study or because, Mr. Speaker, if we just keep on creating structures that we didn't thought of how much resources are we going to spend on it, chances are, Mr. Speaker, the 45% cap, as mentioned in the BOL, will be depleted soon, very, very soon, Mr. Speaker. So my suggestion, Mr. Speaker, is the next step for this is to start looking at the structures that we suggested here. There are so many structures and mechanisms that needs resources, Mr. Speaker. So and my suggestion, Mr. Speaker, is one of the next steps would be looking at the financial aspect, Mr. Speaker.
And not only the structures, because there are provisions here that entail subsidies coming from the Bangsamoro government, particularly in the apprenticeship, the learnership, the OJTs, the trainees.
Yes, Speaker.
There are provisions there of 40% coming from the MOLE, 60% coming from the employers. So I think there should really have been an estimation of the budget requirement for.
If you
Actually,
recall,
Mr. Speaker, that's part of my detailed interpellation later on, Mr. Speaker.
Mr. Speaker, if we recall the education code, there was no amount mentioned. There was no mention. We created so many offices in the education code, and I am part of the draft who drafted that code. We did not put any amount because these are set of laws and policies that will be implemented later on by the ministry. So we cannot estimate how many employees are they going to hire. The code itself is an enumeration of and codification of laws and policies of the Bangsamoro government. So we did not put any amount. The same with the Civil Service Code and the Administrative Code. Codification, Mr. Speaker, does not entail amount because that is so broad, Mr. Speaker. So we cannot possibly do that in just one code to put an amount for all of these institutions that will be created. It is up to the ministry to do that, Mr. Speaker, in their programming.
Mr. Speaker, we cannot compare the labor code with the 3 priority codes, Mr. Speaker, because these 3 codes are specifically require the bus, mandated the bus to deliver, Mr. Speaker. And the respective ministries, the government of the day, deem it to be one of the priorities that should be passed within a certain period, Mr. Speaker. But this one, I don't think we are in a hurry not to compute or not to have a rough estimation of how much resources. Unlike in the past, Mr. Speaker, we don't have yet any structures, Mr. Speaker. But right now, Mr. Speaker, the way I look at it, and maybe we can ask the Ministry of Finance later on, we are seeing some budget problems later on with regards to the PS, given the salary increase at the national level and even in the other issuances related to teachers, which affects our black grant, especially on the PS, Mr. Speaker. And therefore, we cannot be we cannot just set aside all those issues right now, because unlike in the past, we don't have those kind of issues, Mr. Speaker. And therefore, for this particular case, Mr. Speaker, I think for us to defend this on the Committee of Finance, we really need those information, Mr. Speaker. May I proceed, Mr. Speaker?
Yeah, you may proceed.
General question still, Mr. Speaker. Are there provisions that talks about how we introduce some provisions about health hazard or pandemic in the case of COVID-19? Is there some provisions that talks about it in the labor code, Mr. Speaker?
In the code, there is quarantine leave for this pandemic. So there are provisions. Yes. The answer is yes.
Okay, thank you very much, Mr. Speaker. In the crafting of the code, Mr. Speaker, and this is also part of the housekeeping, Mr. Speaker. Have we consulted MBHTE, particularly the Bureau on Skills Development, the MTIT, and of course the MOLE, the new MOLE leadership? Have they submitted legal or position papers regarding this code?
Yes, Mr. Speaker. The answer is yes.
And have we incorporated the recommendations or suggestions of the three ministries?
Yes, Mr. Speaker. They have been incorporated.
Okay. So thank you very much, Mr. Speaker. Those are my general questions. I move now to the detailed provisions, Mr. Speaker. On the title, Mr. Speaker, it says in the last paragraph that we are amending for the purpose section 11, 18, and 19, Title 4, Chapter 4 of the Bangsamoro Autonomy Act number 13. My question is on section 11, which talks about functions of a certain bureau. It's not clear what specific functions are we amending under section 11.
Yes, Mr. Speaker, we are amending the following, Mr. Speaker. Section 241 of the national, for the Bureau of Labor Standards under the national law, Mr. Speaker. We are amending that. We would like to create functions that are for BLRS given to the BCMB or the Bangsamoro Conciliation Mediation Board. So there are specific amendments to the national law, Mr. Speaker. Number one would be from Bureau of Labor Relations, it will now be Bangsamoro Conciliation and Mediation Board who will do the functions that were mentioned therein. And also in other matters like the Tripartite Wages Board, it would be by creating the Bangsamoro Tripartite Wages and Productivity Commission and other sub-regional boards, Mr. Speaker.
Again, Mr. Speaker, in section 11 of the Bangsamoro Administrative Code, there are enumerations, and in fact, there are many functions that are enumerated in there, no? From letter A to letter P, Mr. Speaker. My question is, actually section 11 talks about the Bureau of Labor Relations and Standard Functions. My question is, what specific functions are we amending, Mr. Speaker?
Mr. Speaker, the functions that were amended that will now be by the Bangsamoro Conciliation and Mediation Board would be the following, Mr. Speaker. For the Bangsamoro Conciliation and Mediation Board, the mediation function, and for the Bangsamoro Tripartite Wages and Productivity Commission, and other sub-regional board for the wages, for the regarding wages, matters on wages, Mr. Speaker.
In that case, Mr. Speaker, we are not amending, we are introducing, or we are adapting provisions coming from the National Labor Code, Mr. Speaker, because we have already here the functions of Bureau of Labor Relations and Standards based on the national law. It's already in the administrative code, but according to our title, we are going to amend section 11. The question is, are we really amending section 11, or are we adding up another functions which talks about the mediation board?
Yes, Mr. Speaker, under the amendment, section 18 and section 11 that provides for the function of the Bureau Relation and Standard, section 241 of the Bangsamoro Labor Code amended this because now it will not we are taking away some of the functions, not really amending, but we are amending by taking away some of the functions of the BLRS to be given to the Bangsamoro Conciliation and Mediation Board, Mr. Speaker, as well as we are also providing for the function of the the formerly Bangsamoro Tripartite Wages Board. We are now creating a Bangsamoro
Can we stick
Tripartite
to,
Wages
can we stick to
Commission
section
instead of
11?
board.
Can we stick to section 11?
Section 11, Mr. Speaker. Section 11, instead of the just the function of BLRS, the function as to the Conciliation and Mediation Board will now be given to the Bangsamoro Conciliation and Mediation, BCMB, instead of just a division. It will now be a separate board, Mr. Speaker, not a division under the BLRS. We are now giving jurisdiction to the Bangsamoro Conciliation and Mediation Board that is mentioned here in the Bangsamoro Labor Code.
So we are creating another board. That is the conciliation.
Yes,
Mediation
Mr.
Board.
Speaker. We are creating a board that will be called Bangsamoro Conciliation and Mediation Board. It will no longer be a division. It will now be a board, Mr. Speaker.
Okay, so at least for that, it's clear, no? And later on section 18 and 19, I have separate interpolation. Now we go to
MP Baintan, you have 5 minutes left for today. We will allow you to continue in the next session to interpolate.
thank you very much, Mr. Speaker, because I'm still in page 1, Mr. Speaker. And thank you very much for saying that I'll be allowed to interpolate on the other days, Mr. Speaker. On section 6, Mr. Speaker, it says here, rulemaking authority. My question is, who will approve the implementing rules and regulations that will be crafted later on? And what is the role of the Chief Minister, Mr. Speaker?
Mr. Speaker, under the rulemaking authority, it will now be the Ministry of Labor and Employment who shall promulgate the rules and regulation, and then it will be published in a newspaper or regional circulation in the bar, Mr. Speaker. It is the MOLE.
So it's the Minister of the Labor and has nothing to do with the office of the Chief Minister.
Yes, Mr. Speaker.
Just for the record, Mr. Speaker, because later on, if there are issues about this particular provision, at least we can refer back to this particular discussion, Mr. Speaker. The next is on the minimum employable age. We are very specific under section 8 that the minimum employable age is not below 18 years of age. Am I right?
Yes, Mr. Speaker, 18 would be the minimum employable age.
It's because
Of now, because of the K-12, Mr. Speaker, that the elementary high school will now be 18 years old. So children, they're still considered 18 below are children, they have to be in school, Mr. Speaker.
do we consider also 18 as a legal age, Mr. Speaker?
For purposes of employment, Mr. Speaker, I believe that yes, 18. But in some parts of the code, there are provisions wherein 18 below can be employed, provided that the Ministry of Labor.
exactly my point, Mr. Speaker, and I'll deal with it later on, Mr. Speaker. But just for the record, for this particular section, we are saying that, Mr. Speaker. Next is on Section 10, Mr. Speaker. It's good that the Ministry of Basic Higher Technical and Technical Education, as well as the Ministry of Trade, Investment, and Tourism, and other relevant agencies are mentioned here. But while these agencies are, these ministries are specifically mentioned in Section 10, nothing in the succeeding sections that operationalizes this specific provision, Mr. Speaker. My question is, how do we operationalize these particular provisions when in the specific actions or sections that is supposed to be incorporated, it's not in there, Mr. Speaker?
Yes, Mr. Speaker, we understand that needs to be clarified in the IRR. So the details would be contained in the IRR, Mr. Speaker.
But Mr. Speaker, just for the record, if it's not included in a particular section, Mr. Speaker, we cannot just say that, we cannot just assume that and include it later on in the IRR. If it's not part of the major provision of the law, we cannot formulate an IRR for it, Mr. Speaker.
Yes, Mr. Speaker, if we read Section 10, it's a policy. It's a policy of the Bangsamoro government to provide pre-training for its constituents. So meaning it's an economic policy. It's a policy. It's a broader stroke policy which can be.
May I cut you now the interpellation? It's already time. MP Baintan, you will be allowed to continue to proceed with your interpellation in the next deliberation of this Bangsamoro Labor and Employment Code, which will be next month.
Thank you, Mr. Speaker, because
Tomorrow we will proceed with the Ranao Development Authority.
Thank you, Mr. Speaker.
Thank you very much, Mr. Speaker, for the mention of the Ranao Development Authority.
Session suspended until 1 o'clock tomorrow afternoon.